This short video will explore the background to the Public Records Scotland Act 2011 and set out, very broadly, Scottish Ministers' ambitions for the legislation. The primary ambition of Scottish Ministers is, of course, to improve record keeping across Scotland's public sector. But the backstory to this ambition is key. It's worth noting that the Act was the first Public Records Act legislation in Scotland for over 70 years when it was passed by Parliament in 2011. So we might ask, what exactly was it that compelled ministers to act? Something happened to spike the interest of ministers, and that something was a very public crisis over the records of vulnerable young people in Scotland's care services. The 2007 Historical Abuse Systemic Review Residential Schools and Children's Homes in Scotland, 1950 to 1995, or the Shaw Report, commissioned on the back of claims of abuse by former residents of care, identified thousands of case files of children in care as lost or erroneously destroyed in that period. But Shaw also reported on record-keeping failures in the 2000s that impacted negatively on his review. The purpose of the Act is therefore to help authorities identify and manage their information assets better, to support transparency and accountability, and to better protect the information rights of all of Scotland's citizens. Shaw clearly demonstrated the importance of records to the care experienced. Having no access to formal records about their time in care was devastating, because many of them had no access to the sort of anecdotal information that many people, young people, rely on to know who they are. Stories told at family gatherings, weddings, funerals, birthday parties. These opportunities simply don't exist for many care experienced people. If they are then denied access to a formal record of their time in care, they effectively have no access to their own past. None. No access to their own story. No knowledge of their ethnic, cultural, religious backgrounds, no sense of family or community, no information on family medical histories that might be vital to their own health and well-being later in life. That is tragic beyond words, and it is the lived experience of many of those who came through Scotland's care services, including survivors of abuse. These experiences and the associated records issues are being retold today to the Scottish Child Abuse Inquiry. Unsurprisingly, many care leavers quickly reached the conclusion that not only were the records so unimportant as to merit no proper care, the young, vulnerable people whose lives were represented in the records were also unimportant and undeserving of proper care. A key finding of Shaw was the lack of understanding that existed across the services, across the public and the private sectors, and particularly among senior managers, about the importance and value of records, not just care records or case files, but records generally. They appeared to him to attract very little importance. Scottish ministers responded to Shaw by inviting the Keeper of the Records of Scotland to review Scotland's public records legislation. The Keeper's report, published in 2009, confirmed to ministers that records management concerns extended far beyond the care sector. The moral imperative provided by Shaw was reinforced by the Keeper's report, demonstrating that public records were poorly served by outdated legislation and a lack of proper regulation. Ministers decided to act to safeguard all public records. They went to public consultation on draft legislation in 2010, and in April 2011, the Public Records Scotland Act passed into the statute books. Implementation began in January 2013. So what is it that the Act requires us to do? Public authorities are required to develop records management plans, setting out their arrangements that they have in place to manage their public records, and to submit these plans with appropriate supporting evidence to the Keeper for assessment and agreement. The Keeper is required to develop and keep up to date a model records management plan to help authorities understand what's expected, and the Keeper is further required to develop and publish guidance on the form and content of all records management plans. In order for Scottish ministers to remain informed of the Act's impact, the Keeper is required to lay an annual report before the Scottish Parliament. This allows the Keeper to report on progress under the implementation programme, to record challenges faced by public authorities, but also to highlight success and alert ministers to practice improvements. This was the first time ever in Scotland, across the UK and across many other jurisdictions, that a piece of information legislation placed such a specific and direct obligation on public authorities. And that's something that we should be very proud of. But if we are to remain proud of that and what our Act sets out to achieve, we need to make it work. And by and large, by embracing a collaborative approach, by allowing stakeholders to share knowledge and experience and develop joint solutions, I would say we are making it work. The Keeper's Model Plan, published in 2013, revised in 2019, is a very important example of a successfully developed, delivered and working joint solution. It's not a template to be filled in, but an annotated list of the key elements the Keeper considers essential to good records management. It's important the model plan is not a template, because it needs to reflect your authority's business model. It needs to be a living document, and it needs to be capable of supporting change across the functions of your authority. A one-size-fits-all solution would not support this. The records management elements that appear on this slide will not be used to records and information specialists. These facets are key to good records management practice, whether your authority is large and complex or small and relatively simple in structure. They are universal and apply to public bodies and non-public bodies alike. They provide the foundation to all our records management ambitions. The Keeper's Model Plan is, however, the first time these facets have been assembled into a coherent system and supported by guidance, drawing on practical examples of policies and procedures used by stakeholders to aid compliance. Good records management supports good business decisions. It makes our authorities more efficient and more effective. It supports our ambitions to be trusted by our stakeholders. Trustworthy information managed under robust systems is the bedrock of our democracy, and we know this in this age of fake news and AI-generated information, that this is no exaggeration, and it helps us to meet our wider regulatory obligations. These are not new concepts. UK data protection law and Scotland's FOI legislation have been around for many years advocating for good records and information management. Breaching these laws can bring stiff penalties, which are powerful motivators, but they're very obviously not foolproof. Some of the newspaper headlines that you see here are recent. We clearly have lots to do to change the culture around record keeping, and that's what Scottish ministers want this Act to do. And it's what's needed to happen if these sorts of catastrophes are to be consigned to the past. We are not all in the business of managing the records of vulnerable people, young or old, but that's not the point. Records form a key evidential component of all public inquiries. We need only to look at the current Post Office Horizon inquiry to see this in sharp focus. We need our colleagues and managers to understand that for every piece of information we create as public servants, whether it's to do with housing or education or medical care or policing or forestry or road maintenance, there will be a human being or a community for whom it may be of considerable significance. Records management is about much more than efficiency and good business and regulation. Records and archives are about real people. Not knowing what records existed, or when, or why, and how they were destroyed can have devastating consequences. In this instance, families have been left with no knowledge of what happened to their infants' remains and no means of ever finding out. Think about that for a minute. And this is not unique to Edinburgh City Council. Scotland's local authorities revisited their crematoria policies after this. If anyone in your organisation should challenge you about the importance of records and good records management, remind them of the infant mortality remains scandal. Or show them this statement by a survivor of in-care abuse. I know Chris Daly, and I know he grew up to be a man in his mid-40s, believing that his mum and dad didn't love him. Yet there was a file full of letters and Christmas cards and postcards, many of which tried to explain to Chris why he ended up in the situation that he did. But nobody thought to tell him, and he never got access to that file until he was in his mid-40s. These examples remind us of why records are important and why what we do as records managers is central to the stability of our society. The new data protection regulations introduced under GDPR included the right to be forgotten clause. Chris and thousands of others like him are questioning who cares about their right to be remembered. It's our job as records professionals to convince others around us, those who think this records malarkey is dull, that the impact of failing to manage our information appropriately can have catastrophic consequences for real people, not just care experienced people, but all of us. The current COVID-19 inquiry will remind us of this when they finally report. We need to be able to demonstrate clearly to our senior managers that by not having robust retention schedules, by not ensuring that our information is secure and that our destruction mechanisms are robust, and by not affording records management the profile and resource it deserves, our authorities might breach data protection and FOI legislation, and they might incur the wrath of the Information Commissioner. More important than any of that, in my opinion, is the fact that we will be willfully disregarding the rights of those who depend on us, on you, to get this right on their behalf. Records management isn't just about good business practice, as important as that is. It's about protecting people.